A lot of what we will do in this class will be concerned with the First Amendment to the U.S. Constitution. And welcome. This is Professor Harper, another lecture in Journalism and the Law. So, the First Amendment is 45 words, and it covers 5 different issues and guarantees from the U.S. government to its citizens. So, first of all, it allows that there will be no law with respect to the establishment of religion or prohibiting people from practicing religion. That's number one. Number two is freedom of speech. Number three is freedom of the press. And number four is the right of people to demonstrate. And number five is the ability to petition the government when people think that something is going wrong. What's important here is to note that freedom of speech comes before freedom of the press. And why that's important is that freedom of speech protects the ability of people, of all people, to speak their minds, where freedom of the press, while it applies to everyone, really are for specific individuals who work in the media. So the First Amendment grants, first of all, freedom of speech to everyone, and then freedom of press to those people who practice in the media. So there are a variety of approaches to the First Amendment. And so the first one that we'll look at is absolutism. And the two proponents of this were the late Justices Hugo Black and William Douglas. And what they emphasized is that Congress shall make no law. And that means that no law shall be made to restrict all of the guarantees in the First Amendment. And so what it says is that the federal government is without any power whatever under the Constitution to put any type of burden on speech and expression of ideas of any kind. Okay? And this was first put forward in Ginsburg v. the United States in 1966. And it was in a dissent, which means it was not the majority view. And while Hugo Black and William Douglas proposed this in many different cases, it really didn't get much traction because it really fails to acknowledge that there are other important rights that often conflict with the freedom of the press and freedom of speech. Another one, which is called original intent, and this is usually, I don't like to categorize conservative parts of the Supreme Court and liberal parts of the Supreme Court, but because most people use those designations, I'll use them as well. And the original intent basically goes to the more conservative part of the U.S. Supreme Court. And what it means is that the First Amendment should be interpreted in light of the original intent of the founding fathers. Okay? And the problem that we have with this is that the founding fathers met behind closed doors to work on the U.S. Constitution, so that we really don't have a great understanding of what the original intent was. Another theory is what's called self-government, and this is just after World War II. And so the key words here are participatory democracy, self-government, political speech, so that the primary purpose of free speech under the First Amendment is to allow citizens to govern themselves in a free society. Another view of the First Amendment is that it serves as a check on government. We see this in journalism education and in the media all the time, that the press serves a watchdog function, and so that the purpose of the First Amendment is to protect the press in its function to check the power of government by investigations. There's also one theory which is called the safety valve. 1970s, and the main thrust here is that the free expression can act as a safety valve, allowing critics to vent their anger before they reach the boiling point. Okay, one thing that's really important to remember about the First Amendment is that the First Amendment protects unreasonable speech. Okay, reasonable speech we don't really care about because, that's all well and good. We can go along, get along, and have a decent discussion. But what the First Amendment really does is to protect the outliers, if you will, those people who engage in unreasonable speech from all sides of the political spectrum. There's another theory and application of study about the First Amendment, and it's called social interest at the beginning of World War II. And what's involved here is what's called worthwhile speech versus worthless speech. And speech that serves the social interest should be protected, but speech that is profane, indecent, or defamatory should not. Okay? And the problem here is that we get into a definition problem of what is worthless speech. I mean, I would argue that the attacks of the Westboro Baptist Church, which you may or may not be familiar with, a very radical view of, doing protests at the funerals of servicemen and women, and protesting that, essentially, making outrageous statements that the reason that soldiers die in war is because our society allows gays to engage in sexual activities, get married, etc., etc. The U.S. Supreme Court has found that the the Westboro Baptist Church does have the right to say these outrageous things. I would consider them worthless speech, but the Supreme Court has not, and so, the social interest approach to the First Amendment does have some traction when it comes to something called fighting words. Okay, if I'm in your face and I'm making outrageous statements, you have the ability to smack me in the mouth without doing it, without suffering any recourse, because I'm engaging in fighting words. And it's involved in a Supreme Court case called Chaplinsky v. New Hampshire from 1942, which you'll read about in the book, and there's also an abstract of this important case. Okay. There's also another approach to the First Amendment, which is to protect dissent. 1990, so not that long ago. And essentially the First Amendment is to protect the romantics, those who would break out of classical forms, the dissenters, the unorthodox, the outcasts. And this is really only one of several theories of the First Amendment that's really not, completely, working in terms of, what its extent is, but a relatively powerful notion that, again, the First Amendment is intended to protect unreasonable speech. Okay. Another one, which comes from Lee Bollinger, the law professor and president of Columbia University, and he talks about tolerance, and that the real value of freedom of speech is its ability to promote and teach tolerance. I think it's readily apparent that we're having a bit of a problem when it comes to promoting and teaching tolerance with respect to free speech. Another one is, when it comes to First Amendment, is the philosophy of self-fulfillment, which comes from Edwin Baker, who's a law professor at UCLA. And essentially what he says is that free expression should be protected because of its value to the individual. So this approach specifically disputes the marketplace of ideas theory, and what that is that all ideas should be thrown out there, and the good ideas will gain footing, get some traction, whereas those that aren't worthwhile will be cast aside. So that this theory says there's no objective, discernible truth, that different people perceive truth in different ways, and individuals often make irrational choices and decisions. Now, talking about the marketplace of ideas, This goes back to John Milton and Areopagitica. And Areopagitica was a speech that he made before Parliament. And what he was trying to do was to say, I, John Milton, want to get a divorce, but I can't make my argument known because there are restrictions on my ability to print pamphlets. Okay, and so therefore he said, you really need to do away with the licensing of the free press so that I can engage in a marketplace of ideas, take my ideas about divorce, put them out there, and then we can have a discussion. John Stuart Mill, Oliver Wendell Holmes, and other proponents after John Milton. And what essentially goes here is that the marketplace of ideas is searching for truth, and that good ideas will rise to the top, bad ideas will fall away. So that here, freedom of speech is essentially the search for truth. And as I said, bad ideas, false ideas should be allowed to be heard as good ideas. And in a truly open marketplace of ideas, more useful information will win and displace the less truthful. So truth will win out over falsehood. In terms of what Milton had to say, he said, truth will be in the and though all the winds of doctrine were let loose to play upon the earth, so truth be in the field, we do injuriously by licensing and prohibiting, specifically the press here, to misdoubt her strength. Let her and falsehood grapple, whoever knew truth to be put to the worse in a free and open encounter. John Stuart Mill said, if all mankind minus one were of one opinion, and only one person were of the contrary opinion, mankind would be no more justified in silencing that one person than he, if he had the power, would be in silencing mankind. So put it all out there and see what people think about it. Oliver Wendell Holmes, one of the most famous members of the U.S. Supreme Court, said in an opinion of the Supreme Court, but when men have realized that time has upset many fighting faiths, they may come to believe even more that they believe the very foundations of their own conduct, that the ultimate good desired is better reached by free trade in ideas, that the best test of truth is the power of the thought to get itself accepted into the competition of the market, and that truth is the only ground upon which their wishes safely can be carried out.